Hey everyone, welcome back to today's video. We're looking at a short case involving a self-proclaimed sovereign citizen I've been tracking for a while, who is now facing a DUI charge and chooses to represent himself at a bench trial. As you can probably guess, things don't go quite the way he expected. We'll start by covering his first two court appearances, then move into the third and finally break down the key moments from the bench trial itself. Let's get into it.
Hello, can you hear me?
Yes, what's your name, sir?
Yes, I'm here to make a special appearance.
Well, what's your name, sir? Can you tell me your name?
Don Lyons.
Okay, we're on 2508, CM 2346, State v. Don Lyons, who is here today via Zoom, states again present. Let's see, advised at your initial hearing, you wanted to proceed pro se, without an attorney. Is that still your intent today, sir?
Say it again.
Is it still your intent to go forward without an attorney?
Yes, sir.
Okay, so we have two options today. You can either ask for some more time to either put together a defense or hire counsel or talk to the state about any potential resolution, or we can simply set this matter for a bench trial. Which of those two options would you like today, sir?
I would need to request a continuance to work on my defense.
Any objection? I say no objection. Okay. Looking to age the case, that's fine. So I'm going to reset this for December 22nd at 8:30. So Mr. Lyons, we'll see you back here on that date and time.
Say it again. You said
December 22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346, State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed one additional charge. And it's for count 3 operating vehicle with an ACE of 0.15 or more. The state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500ths of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yeah, so that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today, but what we'll do is we'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that, say January 26th at 9:30.
What date is that?
January 26th.
What's that date? Well, no, I'm mistaken.
Okay, we're gonna do the 28th.
Yeah, 28.
Okay, we'll say January 28th at 10 a.m.
Yes, sir.
All right, so we'll see you back here on the date and time, sir.
All right, thank you.
Thank you.
So what we're seeing here is the same familiar pattern that tends to come up in these sovereign citizen-style defenses: challenging jurisdiction, trying to argue special appearances, and attempting to create procedural confusion that simply doesn't hold up in a real courtroom setting. Despite how confidently these points are often presented, the court has consistently rejected them, and they don't really change the legal position he's in. It's more of the same arguments being recycled with no real impact on how the case is actually moving forward. With that in mind, this doesn't go anywhere new legally, but it does help set the tone for what unfolds next. Now let's move ahead and take a look at his third appearance, where things start to develop further.
All right, Mr. Lyons, can you hear me?
Yes, I hear you now.
Okay, we can get your face on camera there.
That's what I'm trying to do.
There we go. This is 2508 CM 2346, State v. Don Lyons, who's here today via Zoom. State's here in the courtroom. We're set for a pretrial conference Lyons, the first question is, you've been appearing pro se. Is that still your intent, or do you intend on hiring counsel, or do you want me to consider appointing an attorney for you?
No.
Okay. So I'm going to advise you, just in proceeding pro se, you are going to be held to the same standard as if you were an attorney. You're going to be expected to understand the rules of trial procedure, rules of evidence, rules of criminal procedure. Do you understand all that if you go forward without an attorney?
Yes.
Okay, so I think
I had wrote an affidavit. No, I'm still waiting for a response.
okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look
Correct.
to doesn't make any specific requests. It's a request for dismissal of charges, and this does not comply with Criminal Rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial. Set that April 1st at 1:30. So that's going to be the court's order for today. This we set for a bench trial, April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
April 1st, what time?
1:30 p.m., sir.
All right, thank you.
Okay, and that's all for today.
All right, so nothing particularly major comes out of that appearance other than a pretty clear display of misunderstanding from the defendant's side. And instead of adjusting course, that same approach carries straight into the bench trial, where he represents himself but makes very little effort to actually challenge the prosecution's evidence or properly engage with witness testimony. At this stage, we're moving into the trial itself. I'm going to skip over the questioning of the arresting officer since it's mostly procedural and doesn't really add much to the overall picture. What's more important is what happens next, during the cross-examination of the witnesses, which ends up serving as a fairly strong example of what not to do when someone chooses to represent themselves in court.
We're making a special appearance.
Hold on, I'm going to call the case. It says 2508 CM 2346, State v. Don Lyons. It's here today in person. State's President Deputy Prosecutor Tyler Trulock set today for a bench trial on counts 2 and 3. Count 1 was previously dismissed. Michelle, I just say you wanted to note something before we begin.
Yes, I'm here for make a special appearance.
Okay, and what do you mean by that?
Like I know I'm here to represent myself and challenge the jurisdiction.
What's your request to challenge the jurisdiction?
The OWI
Okay,
that was said that they had a warrant for to take my body fluids, but I don't recall seeing that warrant.
okay. Well, the time for challenging any of the procedural issues or evidentiary issues has come and gone. Today we're set for a trial on the facts that matter. So if you have issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh.
Any questions, Mr. Lyons?
Yes. You, what side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side,
So alcohol on the passenger side and on the driver's side.
but she was on the passenger side first, right, when you said it, right?
Yeah.
Alright. So when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. I got him supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file?
So you have to ask questions about this.
So you don't know if it's on file or not.
They have all my body camera, dash camera,
You don't know.
all that. I sent it to him, so I would assume so.
You said the warrant was signed around 6/21.
Well, it was around 6/21, so I'd have read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I can't see it, and I see it, but I really don't recall. And if there was a warrant, you know what I'm saying?
It was
Go about it like that, but I don't recall no more.
No, I should say that.
Like,
Give it a question.
Like I was on, I do, but not right, not long.
Anything up that state? No, you can step down, sir.
Thanks, sir.
So this is the only witness he actually makes any real attempt to question. And even then his entire line of focus stays narrowly fixed on whether a warrant was physically read to him while he was intoxicated and in the hospital. He doesn't branch out into any meaningful legal angles, doesn't probe procedure, and doesn't try to challenge probable cause in any structured way. The kind of areas you'd normally expect a trained defense attorney to explore in a case like this.
Ms. Dominguez, is there anything else you'd like the court to know at this point?
No.
Thank you, ma'am. Mr. Lyons, do you have any questions for this witness?
Yes. That was a while ago, but you know around the time that they took my blood?
I don't remember.
That's all I had.
Anything up that state?
No,
You can step down, ma'am.
Okay.
Mr. Nurtown, is there anything else you'd like the court to know at this point?
Do not believe so.
Thank you.
Do you have any questions, Mr. Lyons?
No, sir.
You can step down, ma'am.
Again, a competent defense lawyer would have used the opportunity to question these witnesses more strategically, possibly challenging procedure or exploring inconsistencies that could at least create some doubt or breathing room in the prosecution's case. Instead, none of that really happens, and the lack of meaningful cross-examination ends up reinforcing everything the state is presenting.
Mr. Lyons, do you have any evidence to present?
And y'all didn't give me the motion of discovery. I was thinking y'all was gonna send it to me. I didn't know I had to file for it. That's my ignorance. I don't have no evidence. No, sir.
So today's trial, the state needed to carry their burden, need to prove beyond a reasonable doubt on count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing. Mr. Lyons, is there anything you'd like me to consider on sentencing?
My grad got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. But what they were presenting, I just that'd be nice.
Any on sentencing state?
Just a few questions here. Mr. Lyons, are you currently employed?
Yes, sir.
Where do you work?
Work at the Penn Station right now, Earth Spot.
Okay. Is that a full-time job?
Yes, sir. Now it is. I was working 2 at first.
And where do you live?
Well,
Louisville, Kentucky.
yes, sir.
Mr. Lyons, do you have any criminal history of any kind?
Yeah, look, right. Like in criminal history,
Yes.
I got a little record. Mainly tried. Yeah, but
So what have you been convicted of criminally?
that's some marijuana. Some marijuana. Pretty much.
Is it possession of marijuana?
Yeah, that's
Okay. Is that the only thing you've been convicted of?
I can think of right now.
No previous operating while intoxicated convictions, anything like that?
That's my first time. The first time.
Thank you, sir.
Let's just hope it's also his last time in a situation like this. As the judge ultimately made clear, the defendant was found guilty based on the evidence presented, along with the expert testimony that went completely unchallenged in any meaningful way. With nothing substantial offered in rebuttal, the court had little difficulty reaching its conclusion. Now with the verdict delivered, the only thing left is sentencing. So let's hear what unexpected outcome the judge decides to impose.
Is any other evidence from the state?
No.
What's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understandably, if I would put you on probation, it'd be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today. You're going to be released 4 days from today. And there's going to be court costs of $189.50. And I'm not going to impose any additional fine. There's a $200 alcohol countermeasure fee. There's also going to be a 90-day license suspension that's going to go into effect tonight at midnight.
That's suspension for the state of Indiana.
Yes. So I'm not sure how that transfers to Kentucky. That's going to be the order for today. It's going to be remanded in custody.
All right. So what about my granny though? She can't really see like that. I gotta help her get her.
Well, sir, you've known for quite some time that you were scheduled for trial today.
Yeah.
And so plans you've made are on you. So that's going to be the order for today.
I'll get out for that.
And I will notify you have 30 days to file a notice of appeal if you want to appeal this decision.
Well, it looks like Grandma might need to arrange a different ride home after all. And it's always worth remembering, when other people are relying on you, it matters to stay responsible, make good decisions, and avoid putting yourself in situations like this in the first place. That includes staying within the law and not trying to turn a courtroom into a personal theory test. And with that, that's the end of this video. It's been a little while since I covered one, and while this one was on the shorter side, there's plenty more content like this coming up soon. If you enjoyed the video, feel free to leave a like. If not, you can hit dislike instead. But either way, drop a comment and let me know your thoughts, and don't forget to subscribe and turn on notifications so you don't miss what's next.